Good afternoon, ladies and gentlemen. This is the October 26, 2016 meeting of the Municipality of Anchorage Board of Adjustment. I'm Baron Creature, the chair. Madam Clerk, you can call the roll, please.
Okay. Dwayne Adams.
Here.
Bernd Guchow.
Here.
John Haxby.
Here.
Don McClintock is excused. Robert Stewart.
Here.
And also in attendance is Julia Tucker, Board Counsel, and Amy Solberg's staff support. You have a quorum.
Thank you. Approval of the agenda.
Move for approval.
Move for approval. Second.
Second.
Been seconded. Moved and seconded. Any discussion? No. I would like to switch the order of the in item 6A, 2 and 3. In other words, I would like to see the hearing date set first and then the selection of the hearing panel. If that's okay with everybody?
Sure.
Is that all right?
Okay, sure.
Okay. I think it makes it a little easier to see who's in town and who's out of town. All right, subject to that change, any other additions, deletions, changes? Seeing none, the agenda is approved. Minutes of the previous meeting.
I move to approve.
Been moved and seconded to approve the minutes. Any discussions? Mr. Stewart.
None. I went through it and it agrees with the things that we did in that particular meeting.
Okay.
According to my notes anyway.
All right. Any other discussion? None. You had brought up, Mr. Stewart, that there is a may that should be turned into a shall, and then item 8, audience participation. And there's the sentence that presently reads, when adjudicating an appeal, the board may consider only the material contained in the appeal packet and may not hear arguments nor take additional testimony or other evidence. I think that was intended to be a verbatim quote of the ordinance. If so, we should comport with the wording of the ordinance which provides for shall not hear argument instead of may not hear argument. So I would prefer that we change that.
I think that's a good part of the amendment.
Yes,
Yeah.
yes. Any other changes subject to that?
No.
Any other discussion?
Does that comport with the AMC code?
Yes.
Yes, it
Shall.
does.
Sorry.
Yes, it shall not hear argument
Rest
nor
of them
take
is
additional
may.
testimony.
That one is shall.
All right.
It's a good detail right there.
Oh yeah, there are some
impressed.
here who are real sticklers for detail.
Well, that brings up a real,
Notice
that brings up a real good question with respect to somebody, I think you approved of the inclusion of a video for the existing case that was not in the evidence. It was not in the
Well,
hearing.
let's first get to this here and let's finish the
Okay,
meeting.
all right.
Okay? Any other discussion regarding the minutes? Seeing none, minutes are approved. There's no old business, there is new business, of course. And before we have, I know that you have a point that you want to bring up, Mr. Haxby. Let us, however, go through. Are there any potential conflicts that the four of us here have, or that should be brought up? Mr. Adams.
Just for the record, I believe the owner of the mall is a client I've had many years ago, but I have no current business nor any fiduciary or other interest in this case whatsoever, as far as I know.
Okay. Mr. Haxby, any conflict?
No other than I stated, I don't think I stated any of the previous one. I don't think so.
Do not recall.
No.
Mr. Stewart, anything?
No, the situation hasn't changed with me.
Okay. And I have no conflict there. Mr. McClintock, just for the record, does have a conflict, and that's why I excused him from being considered for the panel for hearing that case. The record should reflect that. Determination of the hearing schedule. We have very nicely been provided with a tentative schedule here. And it appears that barring any extension requests, the case should be ready for consideration in the middle of December. Now, middle of December is not a good time to schedule an appeal for. It strikes me.
Also, that doesn't allow any time for
For
me
you,
to
Exactly.
prepare anything for.
Yeah.
I mean, the middle of December is when the briefs are going to be done, and so.
well, what is your schedule, Julia?
Well, I figure that if I'm going to work on it, I'm going to start, way at the end and then work backwards. We would, if I'm going to work on this, we would want to make sure that we had it completed before the end of April 2017, because I figure that I am going to be gone here sometime between the 1st of May and the 1st of July.
You mean as in permanently gone?
Yes, yes.
Okay.
yes,
Where are you
yes,
going?
Yes, well, I'm going to stay in Anchorage, but I won't be working.
Lucky you.
anymore. Yeah.
Okay.
So we want to make sure that we get it done before the end of first quarter. At least that's sort of the schedule I've given the assembly, in there. So there's that. Then there are periods where, even within that I'm going to be out of the office attending residual family matters. And so one of those periods is the week of February 4th. I think February 4th is on a Saturday, but that first 10 days of February I've blocked off. And then there may be a similar period in December that would be something like the
Oh, thank you. Oh, that's a little bigger. That's correct.
sometime after the beginning of the 7th of December.
Well,
And,
let's see if we can attack it
maybe the
slightly
15th,
differently.
yeah.
Assuming, arguendo, that all the briefing is done by the end of December, 12/31. Okay. When would your schedule allow you, considering that you usually want 4 weeks, when would you be able to provide us with the memo?
I would have to I think provide, I guess my issue, and that's why I brought up that February. There's that period that I mentioned in February that I'm not going to be available. So I could get the brief to you, by the end of January, but
Okay.
I'm not going to be
Well,
available
let's-
to assist you
Okay,
in
well,
February.
let's
so.
first do that.
Mhm.
Brief in January. Okay.
Right, so let's just say that that's Monday. Well, let's see.
It's actually a Tuesday.
I know it's a Tuesday, but I was just going to say I couldn't. But okay, we'll just do Tuesday.
Okay.
That's good.
And you're going to be out when in February?
I am potentially going to be out from the 8th of February through the 15th or so, February.
Okay. So you would be available during the first week, basically from February 1 through February 7, theoretically. I'm just trying to...
Theoretically, right,
okay.
theoretically, that's right.
All right.
There's an assembly meeting on the 7th of February, so.
Okay, so that's not good. But at least you would be available for questions and what have you. And we could perhaps schedule something for February 22, right? That's
Yes.
the week after you get back.
Absolutely. Absolutely.
Okay, now that's a Wednesday, and we usually do things on a Wednesday or Thursday. So, you think you're going to be good February 22 or 23
Yes, sir.
for a hearing? All right. So then the next question is, when are we all available? Mr. Haxby, are you in town February 22 or 23?
Yes.
Okay. Haxby. Mr. Adams.
I'm here the 22nd, 23rd, but I get off an airplane on the 19th, which is a short period of time for reviewing a package.
Well, wait a minute.
The package should be
The
done at the
package
end of
will be done at the end of January.
yeah.
Where are you going to be?
Hawaii.
Oh, that's not good, is it?
Well,
Well, Hawaii is
It's
good,
not a
but I
viewpoint, but
understand
no.
that.
When are you gone to Hawaii?
January 27th, I think.
So the only thing you would not be able to review is Julia's memo
Correct.
before you leave.
Which could be emailed to you as well.
Yes. And of course, you want to read it as you're sitting on the beach.
That's the perfect place
Mai
to
Tai.
It gives me something to do.
It's
Yeah.
the perfect place to read it.
So, and you're
Saves
always
me.
taking your computer with you anyway, aren't you?
But
Not usually, but I could. It's a lot of caveats. This is the only thing I usually take, but my wife takes hers, so that
Okay,
works.
so it could be arranged. It
It
could
could be arranged, given a choice, the following week would be preferable.
You would prefer March 1.
Yes. But it would work.
then I'd be here March 1 too. as well.
Okay. All right, Mrs. Stewart.
I'm here all three.
Okay.
Prefer Wednesdays because that gives us a better chance to get things cleared up and sign any documents on that Friday.
Yeah, that's a good point. And I will say, for argument's sake, that I will be here in February, but I too would prefer the March 1, I must confess. Julia, how would you feel about March 1?
I like March 1.
Okay.
No, and I'll share with you that has anybody else heard about anything about REI's interest in moving into the old cars slot? Do you know where that's at?
Oh, yeah. It's
I mean, yeah, go ahead. Do you know
It's
where?
at the other end of the Sears Mall.
Yeah, that's where cars is. I'm talking about where that negotiation, or does anybody have anything?
My
up on
understanding
that?
is there's no agreement. It's a tentative discussion, and that's
And
as
it's
far
still
as
in that
it's going.
discussion.
That's my understanding based on a phone conversation I
No,
had
to
Monday.
move
I don't
where
have
now?
involved in that. REI is looking at locating the old Cars Mall space. They have a realtor, and that's where what he's looking hard at. So I guess he's talked to Bob Menzer or whoever runs those negotiations.
Yeah.
So they've run out of space where they are, so they want to relocate into Cars Mall. But there's other people who say, hey, well, give us a chance too. So I'm
Well,
talking
yeah,
to
I
someone
would
who.
suspect there will be some competition.
Yeah.
What does that have to do with this case?
My sense was that that the draw of a significant tenant into the Sears Mall, like REI,
Right.
If there was reluctance on their part to do that because of this or any other kind of impediment, that this could end up getting negotiated out. And so I think that as long as that space is up for grabs here, and that there are active big interests like REI, that
They could put this into
the
hands.
appellants in this case may end up having to choose between whether they want to have significantly more foot traffic sponsored from that end of the potential foot traffic from that end of the mall
Mhm.
than they're getting now from the Halloween store, versus trying to reconfigure space that's already solidly
Configured,
built
yeah.
at the other
Well,
end.
I don't think we need to, or we should, base any scheduling on the possibility that it might get mooted out or whatever. So my.
No, I was
premise
just sharing
would
that
be-
from my standpoint,
Yeah.
I think, but, I don't want to have it be drawn out so that it's impossible for me to work on before I plan on leaving city employment.
Well-
But on the other hand, I'm not, doing a whole bunch of work on it to have it die on the vine isn't a priority for me either. And for that reason, March 1 is appealing, because I think that we
Okay.
should know more, and maybe, March is a significant time period for lease-ups and.
So you
and
think they
stuff
could
like that.
actually, the appellants could actually just drop out and say, well,
Yeah.
wait a second.
Or they would negotiate something with,
Yep.
with the.
Sears guys. and-
Yeah, or with Kargotsky,
With
whoever these
Kargotsky,
people
yeah.
are
Sure.
who have control of the mall. So I don't, like Barron's, I'm not hanging any hats on that or
Yeah.
doing it up, but the reality is that, we're a small
It
enough
could happen.
community, so we have strange bedfellows when everything all
Yeah.
sorts out.
Well,
Okay, so let's leave it at March 1. We all
Alright.
seem to agree that that's a good date.
Okay.
Okay? So, we have, should we do this by motion, just to be on the safe side? I move that the hearing date of the appeal be March 1, 2017.
Second.
And it's been seconded. Any discussion? Any objections? Seeing none, that's the date. All right, now let us talk about the hearing panel. First of all, is there somebody who would like to voluntarily withdraw? That's the very first thing, because there are 4 of us in the panel, there's of course only 3. So is there somebody who would rather not sit on this? Mr. Haxby?
I can not sit on it. I sat on it
Okay.
last time.
Mr. Adams?
It's my turn to do a case, I think, so I'm available.
Mr. Stewart?
I probably need to stay on this just because of some of the orders that I've been
Okay.
involved with.
Okay. So let's do it the easy way. If you feel like you'd rather ride your electric bikes
I would.
on that day,
I would rather ride my electric bike, not in Anchorage, but I'm not going to get a chance to do it. That's fine. Though. No, I'll.
is that
That's totally cool with me.
okay?
I can pass this one out.
All right. Well, then let's talk about the fact that we are having one board member who's brand new to this. This is the second appeal of the second case, of the same case. I'm sorry. Does it make a difference that Mr. Adams has not participated in the first go-around of this?
That was the question I was going to ask as well, is I don't know that it matters, maybe.
Okay.
but
Well,
I don't
that
know.
was my thought was as well. Does it help to have all 3?
Well,
heard
what's
before?
your thought on it?
Well, I was thinking about that when I was driving down here. Does it help to have the same 3 who did it versus having a new person with a new set of eyes and a new perspective on it? When in fact, if this is appeal number 2 for the same case, somebody may say, well, what? 2 separate boards of adjustment, but not the same members, either to the same conclusion or a different conclusion. Maybe if it were to come to the same conclusion, I'm not making a judgment right now. I'm just saying that if it came to the same conclusion, the court may come back if it got appealed again and just say, well, look, sorry,
Yeah.
it is what it is. You guys are tough.
Okay, so where do you come down on this?
My opinion would be it may be better to have a second set of eyes on it, or a third
Okay.
set of different eyes on
Okay.
it. It may be better.
Okay. Mr. Adams, what's your thought?
Legally, I would expect that a body is a body, and that, whether it's planning and zoning commission or whatever, there are numbers of cases that when I was on the planning and zoning commission where we would have a new member, and they did not necessarily, even though it had been heard, they did not abstain from participation. They listened to the record. And the record is the record. The truths are evident in the record. And that's the basis of all decisions, is what the record says. If there were testimony that was not in the record, if there were a body that could hear that or base its decision on that, that would be one thing. That's not the case. It's based on the record that's presented and information provided by Ms. Tucker. So legally, I can't imagine that it matters, and I think another set of eyes may be good, because I will probably ask questions. You'll know the answer, but it's a way of ferreting out a different viewpoint, perhaps.
Okay. Mr. Stewart, where do you come down on this?
I think there's a possibility that, well, let me ask this question of Julia first. Are we going to have the two records merged together on this review to follow it through, or are we going to be starting with the second P&Z hearing and then
I think
coming
we'll be
forward?
starting with the second P&Z hearing. P&Z was directed to hold a public hearing, and they had some questions about, well, that just means we hold a public hearing in isolation, and the answer was no. You hold a public hearing, and then based on the record of the case and the public hearing, then you have to redo, a total redo. And so then what's going to come to you is that total redo, the public hearing that was held, and the discussion of P&Z and the record.
Okay.
that
So
we
this is
have
a
of the
total
case.
new case, new hearing.
It's a new hearing.
If-
Same appeal issues, but a new hearing.
If there are differences in the architectural plans between the first hearing and the second one, will that be included as part of that?
I guess I don't understand the question. Will they be identified
They're-
as being different?
Yes.
I don't know if the record, I haven't looked at the record to see if we have the transcript, and we have the...
Depends whether they
and
came
we
to,
have the-
came to the thing and said, here's this thing from the first one that's now we're going to include this in the second hearing, here's all our evidence. So you may
That-
you may see stuff from the first one anyway, who knows?
But you have a different resolution from P&Z with different conditions.
My view of the
P&Z.
matter is, this is a totally separate case. It really has very little to do with the first case. What the decision of the Superior Court hinged on was whether or not we should hold, P&Z should hold a public hearing or not. Something that we, when we first considered this, thought was kind of a minor matter, and we disposed of it very quickly. So the current appeal is entirely different, and it has nothing to do with the issues that we considered the first time around. And so I don't think it makes any difference from my vantage point whether there is a second set of eyes on this, yes, no. I view this as an entirely new case.
The only thing that I was looking at is if modifications have been made after the Superior Court hearing on it, modifications to egress, ingress, or whatever else in that area.
Yeah, but
Well, that would be brought up anyway to do
exactly.
in the P&Z. So
Yeah.
that,
Yeah.
okay.
New case.
Then
It's a
he
new
would,
case.
he would be aware of that then.
Yeah.
Okay. I don't have any problem with it then.
Okay. I must tell you, as I just said, I don't think it makes a whole lot of difference whether there's a new set of eyes or whether we should say the original panel is going to hear this one. I must tell you, Dwayne brings at times some new perspective to a case that we haven't had, and so maybe from that point of view, it would be good to have him on this, I must say. And since John is volunteering to write his electric cycle anyway, while we're hearing this, so maybe that settles the matter.
There you go.
Any problem with that? I don't want there to be hard feelings over this.
Oh, trust me. I
think
know.
John's gonna work on it.
Yeah, trust me, I don't think I'll hold this against you.
Okay, well, that's good.
One revolution to the pedals and I'm cured.
No, Hawaii will be nice.
Okay, all right. So I think it is done, and the record should reflect that the case will be heard by myself as chair, with Mr. Adams and Mr. Stewart as other panel members. And of course, having said all this, the time can change altogether, assuming, or if there are requests to delay briefing and things of that nature. Hopefully that won't be the case, but we've had that before. So, any more regarding, you have brought up something regarding the record.
Yeah,
Have you looked at the record?
No, I have not looked at the record. However, this was my point. Okay, because I got, and I don't remember who sent it to me. Maybe it's you, Julia. But there was something that came out here recently where there was, and I don't know who submitted it, but I just as we read through this audience participation in AMC 21.30.08b, it was brought up that when adjudicating an appeal, the board may consider only the material contained in the appeal packet and changed by Baron shall not hear argument or take any additional testimony or other evidence. And it was just brought up and sent to us in an email that said, hey, there was a video that was included somewhere in the record versus something versus just pictures that came in the appeal packet.
Right, so what I think that, I have that, also it was generated by Lisa, who received it, you have it right here, from Hal Hart. And so what he is saying is that the DVD movie, which you now have a copy of on a CD,
No, I don't.
or some people do.
Yeah.
Or availability.
Or availability.
Yeah,
Anyway,
yeah.
they sent me a copy. The clerk's office sent me a copy of it, which is a 3-minute long video. It was part of what P&Z considered. But when planning put together the record this time for the BOA, they forgot to put that in. And so that is similar to some other things that happened on other records where in compiling the record by oversight of planning, they subsequently discovered that things that P&Z considered in the case that's now on appeal were not provided to the clerk's office as part of the record. And so when that has come after the fact, after the record's already been distributed, then there's been motions to incorporate those, because it's very important that the appellate body, whether it's an appellate court or a board like this, has the full record of what the body below saw, heard, and had.
Well, then that brings up a point.
Okay.
Which is? The point is that if in fact this AMC is correct,
Mhm.
it's only in the record packet, that should be excluded. However, if it were to go to the Superior Court, would the Superior Court take the record and put it in the DVD?
Well, it is part of the appeal packet.
This is saying no new evidence.
That-
You can't take new evidence here. People can't come on appeal and in their brief attach a whole bunch of documentation that was not heard by P&Z. That's separate and distinct from what...
But that's not what this says. This says, when adjudicating an appeal, the board may consider only the material contained in the appeal packet.
Yeah,
And this is an
Right.
amendment to the
This is
appeal
a-
packet.
it's an amendment to the appeal
It's
packet. The DVD that Julia was talking about.
And so it in fact
it
needs-
was included.
Okay.
Yeah.
It was part of the
Yeah,
appeal
yeah,
packet.
I agree
when
that
it-
this could be
when it was
worded.
said
Maybe
done.
what we could do is, I agree that the shell is in the code. I'd like to go ahead and look at I don't think appeal packet is in the code.
Well-
I think the code says that
find
the
out.
BOA will not consider any new evidence. And so that's
Do you have your
been,
code with you?
Yes.
Let's take a look at it. 2130-080B.
And just bring it up so that
yeah,
you
no,
don't.
no,
Well,
no,
yeah, let's-
it's, there's just a little,
2130-080B. If you can still read that fine print.
I have problems.
Wait a minute.
2130.
2130-080B.
Should be much closer to the front.
yeah, can I take a
Yeah.
look at your book?
It's,
Let
is this the new
Julia,
one?
let Julia work on it.
Let me just see. 21.
Maybe
I
I'm
don't
out of
think
order
it's
for you.
30. I think that, I think
Oh,
it must
03.
be 03.
03.
Oh.
Yeah, so,
So
Come
there's
on,
another
Bob.
typo
yeah,
here.
so there's a
Aha.
typo.
There's a typo.
already.
Yeah, Bob, what's your problem?
Madam Clerk, would you catch that,
Yeah,
please?
yeah, so there's a problem there, and that's why he couldn't find it.
The
And
old one was
then-
30.
Yeah, the old
Oh, is
one
that
was
right?
30.
Yes.
Yes, the old one was 30.
okay.
So 080, and then he
B.
said
So
it
it's
was-
2103.
Yeah,
080B.
080.
080B. 008B.
But this may be old
Well, there's something,
code.
there's no,
Yeah, see,
there's
this
no
is the
single
old code.
digits. Yeah, so it's not gonna be there. So
Is that still procedures?
it's conditional
Yeah.
uses is 2103080. There's no 08s. So
That's-
there's already a typo
I think
in there, so.
it may be 2102, isn't that board? And
Yeah, Bob probably has it marked here. Appeal record. Okay, so let's see, first of all, where does it fall into? Good eye, John Haxby.
Yes.
Okay, so it's
You tell me.
2103-050. And then jurisdiction of the board, appeals to the board, appeals before the board. Written arguments, reply briefs. Procedure.
And I remember.
Okay, all right, so here's the new one. Conduct of hearing, so that is under, okay, so we got to 050, 050, A 10,
Okay.
small b.
Little b.
The Board of Adjustment shall not hear argument or take additional testimony or other evidence. Shall not,
Mhm.
right? The Board of Adjustment may consider only the matters contained in the appeal packet. So, when you have an appeal packet that is deficient, they make a note of it to the chair, and the chair has to open the appeal packet on a showing that it's not additional or new evidence, that it was evidence that was heard by P&Z.
It was simply overlooked or
And
not included for some reason in the packet.
Well, how does, take for instance, a deposition
Mm-hmm.
that's taken, and it may be part of the record, but it's not submitted as part of,
Well, it would have to be.
they have a duty
Yes.
to submit the entire record of everything that was considered and put before P&Z. Otherwise, the appeal is going to be deficient for lack of having the full record. As an appellate board, whether it's a board or a court, they have to have the full
So-
record that was put in front
so
of.
then that was my question.
Mhm.
If it went to a court, would they rely only on the appeal record, or would they go back to the actual P&Z and say, give me the whole record?
No, they would rely on the appeal record, assuming that that's the correct
That it's
record.
complete.
That it's complete from P and Z.
If the appeal record is not complete,
Mhm.
then one of the parties to the appeal can appeal to the court and say that the decision of the appellate body is
Based on a
deficient
deficient record.
That's
Yeah.
right.
Based on a deficient record.
Right, was
Right.
based on,
Okay.
and therefore
So-
fails.
So they would call and say, look,
Yeah.
the record was deficient, so it's,
Then they'd remand it back to you and supplement the record, but you can avoid that by supplementing the record early on so
yeah,
that you have
okay,
a
okay. I just thought I would bring up the
Right, no,
point.
no,
All
it's
right.
it's a good catch all the way around, because I don't particularly care the way, we didn't, you know.
Who caught it, the appellant or the appellee?
You caught it. Oh,
No.
the planning
Okay.
department, when they reviewed it,
Caught
realized.
that the DVD was not
Yeah,
included.
yeah.
And the
All right.
note from planning also indicated there was testimony involving this in front of the P and Z.
And they just failed to indicate.
Yeah,
Failed
yeah.
to include.
All right,
Okay.
let's go back to what led us here in the first place. I think the statement is correct now that we have amended may to shall. I think the last sentence is adequate. It is just that the AMC reference is incorrect. So,
Well, the
Right,
verbiage,
I
the
think it
whole
would
verbiage
be-
is different. so
Yeah, I
either-
think
Well-
that what you should do here is, there's only 2 sentences in the code, and maybe if you're gonna include it at the bottom, you just take verbatim the code and the correct sentence in
does
both
this
sentences.
A10B also refer to the fact that audience participation may not concern adjudicatory matters?
No,
No.
but it does, but the A10B also says no new evidence, no additional evidence, and that's missing out of here. This
Yeah,
just
but it
says-
simply says, may consider only the material contained in the appeal packet, and we know that the appeal packet doesn't contain,
It's
consists of
deficient.
additional.
We know that the appeal packet is deficient in this case.
No, we're past that, we're
Okay.
past that. So, we're only talking about new evidence. Do we want to, because if we tinker with this language, then we also need to have a statutory reference to audience participation may not concern adjudicatory matters before the board. Where's that coming from?
That's coming from something else, and so,
But you don't know what it came from.
well, I'd have to look and
Maybe the
see
old
what
AMC.
it's not, it actually isn't in Title 21.
Okay.
Okay, so it's a procedural thing that has to do with,
That's board rules.
well, it's not even
No,
in
we
board
don't have board
rules.
rules.
There are board rules in Title 4 that apply to all boards and commissions,
for all, yeah.
including the Board of Adjustment. But this thing is actually, I believe, the audience participation was something that is spelled out in, for the assembly.
Okay.
And it was the subject of a conversation that you, Bernd, and Dennis Wheeler and Barbara, the clerk, had outside of my presence. And so I'm not even sure that this, I was late to the table and am still unconvinced that any adjudicatory board has to have audience participation. But what my understanding is that there was a code section about any public meeting, and that public meeting code section, which may be in Title 1.35 on public meetings, says that as part of any public meeting, you shall have audience participation. I looked at that and I said, that's not the kind of public meeting for an adjudicatory
Yeah.
hearing. And so, so that's a separate whole other thing. The board has decided that this one will have this adjudicatory audience participation. I think it's ludicrous myself. It's nothing that I would ever recommend to this board. I don't know that the present municipal attorney would think that it's smart to invite audience participation on an adjudicatory matter. I've never seen it in any other forum. When the assembly has adjudicatory proceedings. They do not invite audience participation. It's like saying, okay, anybody want the jury to say anything to go to the jury before it goes in? Or now that the jury's come back, hello, audience, you want to tell the jury anything about what you think that they decide?
Why don't we do this? Why don't you, Julia, when you have time, tinker with this whole paragraph a little? But for the time being, we simply change the statutory reference and leave it, just for the time being. Instead of 2130.080B, we say 2103.050.810B. And just
Yeah,
leave it
mine
at that
says
for the
that
time.
I mean, this is the one that I have
Well, this is
for,
not the one
here's
that...
your,
Not the one I have.
here's your, I know,
Oh,
so,
that, okay, there's on the agenda is,
Oh.
That's the current.
Oh, okay,
And
all right,
we're
so
under
we
the old-
very simply just say there was a typo here and we need to have the proper statutory reference.
well,
Okay.
was this case started under the old,
Title
the
21.
old code?
This is a new case. Oh, I see, the one
The
that we
language,
considered.
yes.
Oh, I can't remember.
I
Off
think
the
it
top of my
was.
head, was it? Was it the old
Well,
one or
this,
the new one?
I've seen this in here,
I think
Forever.
No,
well, I
I
haven't
think
been
it-
around forever,
I think it
but,
was the new, we were under the new one, because if I remember correctly, we,
well, last year in 2015, you could do old code or new code.
Right, that's right.
And that's why the question is coming up.
it was new code because, as I remember, they had a comment where the land use reconsiderations had to do with, under the new code, that it was a minor
Okay,
change. So I think it was done under the new code.
okay, all right. So,
I don't
the
know, but
record
this
shows-
appeal, I think, has to be done under the new code because you don't have that option.
So the record,
2016.
coming back, Madam Clerk, coming back to the minutes, okay, that we approved, there should be one further change, and that is in paragraph 8, the statutory reference should be changed to AMC 2103.050.810 little b,
Yes.
okay?
Okay.
Which is
And-
the same site that you have on,
Yes.
at the
And-
bottom of there, yeah.
Yeah.
Julia, if you want to attend to this first sentence regarding the audience participation, if you have time to sort that out a little bit more for us, be my guest.
Sure, and I think
If you
that
have time to do that.
I think that just in general, when a code section is relatively small, then I'm always a proponent of, instead of paraphrasing it or using half of it out of context, that both things go together, that the appeal packet only makes sense, the reference to the appeal packet only makes sense if you also explain that it's no additional evidence. And so I'd like to just suggest that we quote the actual statute
I would
there.
agree.
And then we can also dink around with the, and get some clarification from the present municipal attorney.
All right, so you would prefer to have the actual language of the ordinance there instead of the paraphrased version?
Instead of one section of it being taken out of context without the other critical part, yes. Because I don't think it's just John that's going to have a confusion about that.
I guess,
And Dwayne, you agree with that?
yes, I do. I'm.
Bob, how do you feel about this?
I'm still concerned if we were using the old code, if this was filed under the old code, that
But
would
it wasn't.
explain.
We have already resolved that.
I don't know, Mr. Haxby was
Yeah.
speaking from his memory. I
Yeah.
don't know that the first one was filed under new or old code. We
I-
don't have it in front of us. And
No,
so,
but my memory
My
serves,
memory
my
is- yeah.
memory serves me that said there was long discussion about, in the old code, where you have a limited site plan change, that somebody had said when they went to the new one, it had something to do with this was exempted from the old code for this specific change, limited site plan. There was discussion about that in our meetings, and so my recollection.
My recollection is they filed under the old code. And so.
My notes indicate that this was appealed under the old code. It was-
And I think we did have a discussion about the
2014-4.
difference between the old code and the new code, so.
So we're really getting hung up on something that's fairly esoteric here. Was it under the old code? Is it 2130 080B?
Yes.
Okay, so at least as far as the old code is concerned, that is the correct statutory reference.
Yes.
Okay.
And there's still that, the shell is in both the new code and the old code.
And what I thought, when the discussion was triggered, I thought that you were, even back then when it was triggered, talking about going forward, what will we do for continuous improvement? I didn't realize that the attempt here was to go back and change something that was already, I mean, if that's how the clerk was sending it out in minutes, then that's how you got it. And so,
Well,
See-
nobody has seen it except for us, if that's what you're referring to. Those minutes were not seen by anybody else. Because we're just approving it now, or have approved it, and are tinkering with it again.
yeah, my suggestion is that the minutes stay like they are, that you've approved them. I think that it was the old code, I think that it's in there. I think John Haxby's question was about this new appeal, which we know is filed
Yeah.
under the new code.
Under the new code.
And his question was, you know, just like we say over and over again that we can't open up the record, how is this thing different with the CD? And so I don't think that John was asking us to amend the old minutes. He
No,
was,
no.
it just triggered
No.
his,
Not at all. I wasn't asking for any change. The only question had to do with the DVD, this new case. Everything else, I don't go to. It's-
And in my notes, in our, from our meeting, large retail establishment, the definition we were using was under
Under the old
2155,
code.
130, which was the old code.
yeah.
Okay.
All right.
So I don't
Good.
think there's any
So
need
we are-
to change that.
All
And I
right,
just think
so-
going forward, we want to make sure
All
that.
right,
when you
so
put that
we
at the bottom-
simply, I will simply remind Lisa next time around that when she prepares a new set of minutes.
The
we have-
language in the old code says the Board of Adjustment shall not hear argument nor take additional testimony or other evidence. The Board of Adjustment may consider only the material contained in the appeal packet. That's
Right.
what this paragraph said.
And that was 080.
Yeah, 30/080B.
That's,
Well,
that was.
it's really a moot issue anyway, because it's a new appeal.
Right.
You guys are going to be
But
considering.
we're not talking about the new case, we're simply talking about the minutes here. And
Then the references were correct. 080.
I think the
References
references were
were-
correct for
Yeah,
the old
it was.
case.
The only
and-
difference is the shell.
yes,
Yeah, and I don't think you go back and fix that now because that,
correct.
I guess the only question is why do we, this is a record of the minutes. Why do we need that in there at all? I guess that's the question I have, but
It has all,
Well, he reads it in,
He reads it into the record.
Into the record.
every
because
time.
they read it into
okay.
the end.
Yes.
At
That's
the end, when all
why.
the people hearing it are getting ready to chomp at the
That's
bit
right.
and start
Right.
going
I
to
do
town.
remember that.
Yeah.
Barry reminds them that you can't.
Right.
I
You
know.
can talk and say,
They were-
this is happy birthday,
And
but you
today
can't
is
talk.
Wednesday, but you can't talk.
talk to the
Yeah.
merits.
Yeah. Okay, all right. So, now that we have confused you totally,
I think I'm okay.
are you okay?
Yes.
All right. So, that be, all right, good. Anything else for the good of the order? There is no other additional item on the agenda, so now is your opportunity if you want to talk about something entirely different. Hearing none, the meeting is adjourned.